Good morning, distinguished participants. I am Akmal Azad, Director, Bangladesh International Arbitration Center, BIAC. It's a pleasure to host this webinar jointly with Singapore International Arbitration Center, SIAC. I would now introduce the Chief Executive Officer of SIAC, Ms. Lim Seok Hui, who practiced in Singapore and Hong Kong Special Administrative Region as a corporate and merger and acquisition lawyer with international and local law firms. She was called to the Singapore Bar and Bar of England and Wales, and is also admitted as a solicitor in England and Wales and Hong Kong SAR. Ms. Lim previously held a concurrent role as the first CEO of the Singapore International Mediation Center, SIMC, and currently sits on the board of directors of SIMC. I would now request Madam Lim to make the welcome address.
Thank you very much. Mr. Rumi Ali, CEO of BIAC, Mr. Akmal Azad, Director, BIAC, ladies and gentlemen, good morning, good afternoon, everyone. Thank you for taking the time to join us for today's webinar. We are delighted to be co-hosting our inaugural joint webinar with our friends at BIAC. Thank you for your excellent organization of this event. Thank you also to our distinguished speakers and guests for making the time to join us. Today's webinar theme is topical, given the exponential growth in cross-border activity in the real estate and construction sectors in recent years. International arbitration is the leading choice of dispute resolution mechanism for cross-border disputes. The choice of a place to arbitrate and the arbitral institution are key to the expert, efficient, and enforceable resolution of cross-border construction disputes of all sizes and complexities between parties from diverse legal systems and cultures. The COVID-19 situation has raised new legal challenges alongside commercial disputes, and arbitral institutions must stay nimble and responsive and adapt to the new normal. For those of you who may not be familiar with the international arbitration landscape in Singapore and SIAC, let me share some recent developments. Singapore is among the top 3 most preferred arbitral seats in the world, and SIAC is among the top 3 most preferred arbitral institutions in the world. This makes Singapore and SIAC the most popular seat and arbitral institution in Asia. Although parties need not choose Singapore as a seat when they choose SIAC, they are free to choose any jurisdiction, including Bangladesh, as a seat. In practice, Singapore continues to be a popular choice. SIAC is where it is today because of Singapore. The Singapore government is committed to promoting and developing Singapore as a leading dispute resolution hub. There is no better example of this than the fact that the United Nations Mediation Treaty is named after Singapore. On the 12th of September 2020, the Singapore Mediation Convention came into force. This convention will further enhance user confidence and increase the use of mediation as an alternate dispute resolution option, which is complementary to litigation and arbitration. Singapore also regularly updates its international arbitration legislation, most recently, a couple of weeks ago, to align with global best practices and to be responsive to evolving user needs. SIAC is a relatively young institution. We started in 1991, and we celebrate our 30th anniversary next year in 2021. In the last decade or so, our caseload has increased threefold, and our annual caseload has consistently exceeded 400 cases in each of the last few years. Our caseload this year has continued to experience strong growth, notwithstanding the COVID-19 situation. SIAC is a global arbitral institution with one of the world's highest international administered caseloads. Over 80% of our cases are international, and about half of our cases have no connection with Singapore. In the past 5 years, SIAC has handled cases involving parties from over 100 jurisdictions, including Bangladesh, with an aggregate sum in dispute of over $35 billion US. In 2019, SIAC received cases from parties from 59 jurisdictions. This is testament to our global appeal to users from all over the world. In addition to parties from India, China, and other Asian jurisdictions such as Indonesia, Malaysia, the Philippines, Thailand, and Vietnam. Other top foreign users at SIAC include the US, UK, UAE, and European parties from Germany and Switzerland. Over the past 5 years, we have seen a small but growing number of Bangladesh parties at SIAC in the trade, maritime shipping, and commercial sectors. We intend to do more in Bangladesh with partners like BIAC to promote international arbitration as an effective and time and cost-efficient dispute resolution mechanism for Bangladeshi companies, businesses, and investors in their cross-border transactions. We hope you will consider using SIAC in your international contracts. Despite the COVID-19 pandemic, SIAC has remained fully operational. Efficient and effective case management continues to be our top priority. Many SIAC hearings have gone virtual, including emergency arbitration hearings. This year alone, SIAC has handled 15 emergency arbitration cases, 11 of which were received between April and October during the pandemic. In order to promote virtual hearings, we have recently released the first of the SIAC guides called Taking Your Arbitration Remote. It is essentially a checklist of do's and don'ts for users who are unfamiliar with remote hearings. Maxwell Chambers is the world's first integrated dispute resolution complex. It offers world-class hearing facilities and is home to SIAC and many other leading dispute resolution institutions. So SIAC manages cases, but we don't offer hearing facilities. That's offered by Maxwell Chambers. Maxwell Chambers has state-of-the-art audio and video conferencing technology and provides virtual hearing as well as hybrid, so a mix of in-person and virtual hearing services. We've stayed connected to our users worldwide virtually. In addition to online webinars such as this one and online training programs, we held the SIAC Congress, our flagship event, virtually for the first time last month. The Congress attracted over 1,000 participants from 6 continents. Our online training workshops have been very popular. We've conducted, in the last few months, several editions of the SIAC Academy online. And making a small plug here, we will be organizing the South Asia Academy in November, on the 6th and 7th of November this year. The training faculty will be chaired by Gary Bourne, President of the SIAC Court of Arbitration, and will feature members of the SIAC Court of Arbitration and other leading international arbitration experts from various jurisdictions, including Bangladesh. Feedback on our Academy program has been extremely positive, and I encourage all of you to sign up. Finally, in terms of what we have been doing during the pandemic, we came up with a live help desk feature on our website, which enables users to contact us and to get their questions answered in real time during business hours. And Shwetha as well as Piyush, who will be speaking later, have both manned this live help desk, and it's been lovely to actually talk to our users and hopefully for you to get useful tips and get your answers to your questions. The pandemic has changed many things in international arbitration, but it has not changed the key factors that users consider when choosing an arbitral seat and an arbitral institution, namely neutrality, independence, integrity, efficiency, transparency, and political stability. The use of technology to hold virtual hearings has strengthened Singapore and SIAC's value propositions, as we are no longer subject to the tyranny of geography. SIAC is an institution that you can continue to trust and rely on, and we will not let you down. And on that note, I wish everyone an enjoyable and productive webinar. Thank you.
Thank you, Madam Lim, for your enlightening address. We look forward to work with SIAC more cohesively in the future. Now I would introduce Barrister Ali Asif Khan, today's moderator, who is an advocate of the Supreme Court of Bangladesh. He was called to the Bar of England and Wales from the Honorable Society of Lincoln's Inn. He is partner of Hussain and Khan Associates Law Chambers, Dhaka. He specialized in corporate documentation and legislative drafting. Barrister Khan worked as legal advisor of Bangladesh Telecommunication Regulatory Commission and drafted the Bangladesh Telecommunication Amendment Act. He is also retainer legal advisor of the Rupur Power Plant Company. Over to Barrister Khan.
Thank you, Mr. Akmal, and a very warm welcome to all of you, our distinguished panelists and honorable guest, for taking your valuable time and join this webinar. Today's topic is the challenges of application of industrial ADR in real estate and construction dispute in Bangladesh. And I would call upon each of the speaker in chronology. And please note that each of the speaker will have 5 to 7 minutes to share their valuable experience and give us inputs about the industry and the nature of dispute and difficulties they face. So I would, without further ado, I would now like to call Mr. F.R. Khan, the Managing Director of Building Technologies and Ideas Limited, who has a 37 years of experience in the real estate sector and is a member of and advisor of Real Estate and Housing Association of Bangladesh, the REHAB, for the last 25 years. Mr. Khan, please take the floor.
Thank you very much, Barrister Khan, and all the panelists and other guests, distinguished guests who are present here. I will try to finish it in 7 minutes, as you have already said. And let me give you a little introduction of the real estate sector, which we started in 1984. And in these 37 years, we have come across many situations. And the alternative dispute resolution, or the ADR, is of course, alternative to the out-of-court solution of any kind of dispute. But it was mostly informally in the earlier days, and people used to go to the civil court and get themselves very much elongated process, in enumerated process, and in many terms, in terms of money and harassment were there. However, the laws relevant to the ADR process were inadequate in various legal and legislative aspects. The ways were not uniform for ADR in Bangladesh. BIAC, which was launched, I suppose, in 2011, was a big help in business and investment settlement, in commercial dispute, out of court quickly, and it's transparent, cost-effective, and a structured and institutional mechanism is there. It usually, what I know it does is the mediation, settlement, conference, neutral evaluation, and arbitration. Well, most of the common forms of ADR are mediation and arbitration. They have many other forms, in particular judicial settlement, conferences, fact-finding, ombudsman, special masters, and others. It's important to distinguish between the binding and the non-binding of ADR. What happens here, if it is a non-binding, then the negotiation, mediation, or conciliation depends on the willingness of the parties to reach the voluntary agreement. Whereas in the binding, the arbitration procedure must be followed. If they disagree, the decision, they can definitely go to a judicial court system. The Real Estate Act 2010, actually, which I'm quite a part of it while it was being formed, is a very, very strong tool for the developers, for the clients, for the landowners, and all stakeholders concerned. I will definitely stick more to real estate. Later, I'll come to construction. Now, the Real Estate Act has a clause at the end that before you go to a dispute, it must go through first the negotiation, then the mediation and arbitration prior to going to the court action. In our law, as far as I know, the section 89A and B of the Code of Civil Procedure 1908 deals with the provision of mediation. But if the mediation succeeds, that's fine. The disputed parties sign an agreement and it's mutually given to the court if it is already in the court and court passes a decree. If it fails, then either the court takes from the point where it stopped or a fresh suit is done. That is the general procedure as far as I understand. Now, challenges in the application in the real estate sector in Bangladesh today are as follows. The concept of ADR actually comes from like 7 or 8 kind of settlement which are practiced in this country, particularly in the village, like the Family Court, the Arbitration Act 2001, the Village Court, the Constellation Disputes, Municipality Area, the Orthodox Adalat, the Muslim laws, the Code of Criminal Procedure, and the Bangladesh Labor Code, and so on. But in real estate sector, how the dispute starts? The dispute may arise within the family, I mean, the family members of the landowners or the clients, usually the landowners, when they sign a joint venture agreement with the developer. And when we ask for, okay, we first try to sort it out, although we are not a party to it, but okay, say there are three sisters and 2 brothers, they have a problem at the middle of the venture, and then the work stops, and we ask them to settle. We try to mediate from our side. Finally, we ask them to go to the BIAC for a settlement. And here, our Honorable Mohit is here, and he knows that we had a dispute of the landowners like that. We went to them. We had a hearing, and finally, no judgment could be given. So it ended up there. Now, unlike the court, what happens in the court system? If the court thinks they can put an injunction, they can put a status quo, or they can put in the lower court, they can put some kind of binding for that time being. Of course, after that, you can appeal and go to the higher court. But in ADR, nothing is imposed or imposable that the party has to really abide by. And that's what really happened in that scenario, which I just described. It's a very simple scenario, and that could be solved 2 years back. But because of egoistic matter, not understanding the implications of cost and time and other hassles, it went alone. So finally, of course, thanks to Mr. Mohit, that still it worked. And finally, we are in a process of settling it, but on the process, as a developer, we have suffered, and the major loss we are giving. Now, this is between the landowner among themselves. Then the next could be a dispute between the developer, for delaying or harassing the client or the landowner intentionally or unintentionally. And in that case, the developer himself, I'm talking in representing all the rehab members. So the developer himself wants to drag the issue because he thinks that time, if he can buy time, like 4, 5, 10 years, then he can come out of the problem. So he's very reluctant. The developer himself is very reluctant to go to ADR and sort it out because maybe he doesn't have the money or the resources to sort it out. So this is like a default case in banks. Mr. Anis is here. He knows the default bankers in Bangladesh, what they do similar way. The third kind of dispute that might arise between the client and the developer, the earlier one I said is the developers wish to drag it on. In this case, the client is defaulted in payment, and we really follow the Real Estate Act very meticulously, and we cancel it in time, whether we give a loss, whether it is sellable or not. Now the client wants to really take it to the court instead of ADR or mutually agreeing to something with us, because again, he can drag it for a longer time, and by that time, the client might think that his earning or business might be better, and then he can sort out and waive many of the charges that has been imposed on him for delay payment. And finally, the module of BIAC, the Bangladesh part of international arbitration, comes to, I don't know really whether it is a way to make it more effective by way of imposing what has been the decree of the arbitration board, if there is a decree that is given. Because if even that is given for a shorter time and you can make an appeal by a lawsuit, still it becomes much more effective in that way. That's one of my recommendations. And last but not the least, the cost of ADR here is in BIAC is not so, I would say, optimal, because it has a cost, which is engaging the lawyers, the BIAC fee and everything. Of course, BIAC has a lot of facilities, is excellent in its setup, but the mindset of the concerned parties, they think that if I spend certain thousand or lakh of taka, it's better I go for a smaller suit and drag the thing. So this can be reconsidered in terms of cost basis. And coming to the construction side, usually in international construction, we had only one contract with Japanese Tokyo Electric Company, and in that clause of dispute, they asked to keep the SIAC as the arbitrator if any dispute comes, but we insisted to keep BIAC, and since we have BIAC in our own country, and finally they agreed to it. But alhamdulillah, we didn't have any dispute. It went very nicely. It is the underground power system that has been built now in around Dhaka. We are a consultant to that. So that is construction. Usually the owner or the contractor or the vendor, they have international disputes. As a person from BTI and not really a contractor, I really don't know what kind of exact problems comes in. But if that comes in internationally, as for my knowledge, yes, it is very much solvable. So through ADR, which is in Singapore based, and the third topmost ranked, as just told by the CEO, and I'm sure that those can be sorted out. We are going internationally now, so if time comes, definitely, and God forbid, if something happens, we'll immediately refer to that and ask our associates to do the same. Thank you very much. That's all from my side. If you have questions, I'll answer it later. Thank you.
Thank you, Mr. Khan, for that wonderful speech and sharing your experience. I would now like to call Mr. Tejas Karia, who is a member of the Singapore International Arbitration Center, of the Court of Arbitration, partner and head of arbitrations, Shardul, Amarchand, Mangaldas and Co. He has a wide experience in dealing with international commercial arbitration across various sectors, and he has represented multinational and Indian corporation and institutional arbitration seated in India, UK, and Singapore. He was also part of the committee for the Law Commission of India for recommending the amendments of the Indian Arbitration Act. Mr. Karia.
Good morning and good afternoon, everyone. I'm grateful for this opportunity to speak at this webinar of Bangladesh International Arbitration Center. On behalf of SIAC as a court member and myself, I'm really grateful for this interaction. I'm going to talk about international and domestic arbitration in construction and real estate sector, and what are the challenges we face while doing the institutional arbitrations in this sector. And construction and real estate sector is quite different than other sectors, and they use ADR as the main means to resolve their disputes, because we see parties from different jurisdictions and then they don't want to submit to the court jurisdiction of each other. And we have seen number of construction companies operating in different countries. It could be in India, Bangladesh. We have seen parties from Korea, Japan, very active in large construction contracts. And if you talk about SIAC, construction dispute was number 3. There were around 76 disputes of construction in last year, after say corporate disputes of 140 and trade of 100. So in terms of the industry, it's the third largest market player in terms of resolution of dispute. It is quite different than other sectors. Why? Because there are multiple parties which are involved. You have project management consultants, you have subcontractors, you have vendors, suppliers, contractors, and that makes the dispute resolution very difficult in terms of resolving the disputes when it comes to the actual dispute, because every contract is linked to the other contract. The other main issue which also arises is with regard to the expert evidence, because we will have to quantify the loss in terms of the delay analysis, the design defects. All those issues are very important and experts would be required. Third thing is getting an interim relief and how soon interim relief is got in terms of protecting the subject matter of arbitration. And fourth is with regard to third-party funding. So I'm going to deal with all these 4 aspects very quickly in the limited time I have. So starting with joinder of parties, because that's a tool while we can avoid multiplicity of arbitrations, and number of parties who are involved in different contracts can then be joined into one arbitration. And that's the challenge we face while doing arbitration in an ad hoc world where we have no institution involved. That becomes all the more challenging, because parties may tend to appoint different tribunals to decide similar issues arising out of the different contracts, but for the same project. And that creates a contradictory judge awards, which at the time of enforcement also court find it very difficult to enforce, because there is obviously a link between the parties. But when we come to say institutional rules, and for example, if you talk about SIAC, there is a provision under the rules that provide for consolidation or joinder of parties. And as a court member, I sit on various of those cases, because before constitution of tribunal, the power is given to the court to consolidate various arbitrations. And after the tribunal is formed, it is for the tribunal. The beauty of these rules is that if you have multiple contract, a party can give one notice for arbitration without prejudice to their rights of raising an objection with regard to the jurisdiction of the tribunal. And that is deemed to be a notice issued under separate contracts. So if you have multiple contracts and it is compatible with each other or arising out of the same relationship, of course, there are parameters at the time of consolidation which either the court or the tribunal will decide. But that is something which is an advantage of choosing an institution when you have multiple contract. And in construction and real estate sector, we have seen in invariably we have multiple parties involved in these arbitrations. So what to be kept in mind while drafting this contract is either to have a same identical clause having the same institution, or have an umbrella arbitration agreement where you can have a clause which will cover all subsequent contracts where the joinder and consolidation is provided. So that is something is to be kept in mind, but this challenge we face every time, and drafting can really resolve this, and choosing a right institution who has the provision of consolidation is a very important aspect at the time of drafting. And here we have SIAC, and I'm sure BIAC would also have the same provisions for consolidation, and we need to be sure that we are following those rules to the fullest extent. The second aspect I wanted to deal with regard to expert evidence. Now, expert has to be involved at the early stage of the arbitration, and if we don't involve expert at the early stage, it becomes very difficult for the tribunal at the later stage to involve expert, because your drafting of the claim would not have the benefit of the expert's views. And therefore, there are a number of advantages of having an expert in identifying the delay, in identifying the quantum of loss, and also for the defects. Now, various rules provide for involvement of an expert. Now, again, taking example of SIAC rules, the rules provide the tribunal to reduce the cost and time when it comes to expert evidence by directing that the witness testimony to be presented in a written form. And there is also a provision where normally we use is hot tubbing, where both experts, like if there are two experts from different parties, they are brought together, and an expert evidence is led before the tribunal simultaneously, where the tribunal can also have an advantage of asking the questions to both the experts and reducing the differences between the two. Even the tribunal is given power to appoint an expert if the tribunal feels that if there is any technical issue which requires an help of an expert. The other advantage of institutional arbitration is that if the dispute is highly technical, that the institution can appoint an expert as an arbitrator on the tribunal, where you have an advantage of having an expert and deciding the dispute rather than giving an evidence. So that is another advantage, that the institution will take care of it at the time of constitution of tribunal. If the parties have specified in the contract a qualification of an arbitrator, obviously then it is binding on the parties. But if not, also wide discretion is given to the institution at the time of deciding who the tribunal should be. This will also help in managing time and cost. And we have done a number of arbitrations where we have seen that the experts sitting on a tribunal really help to reduce the time and cost in terms of explaining. We were just doing one big construction contract for tunneling for Indian Railways. And we have two technical members, and half of our job is done by the time we come to explaining the technical aspect, because they already know about it. In fact, the discussion, it is very high level, where you are able to explain them the concept which they really understand. Just yesterday, we got an award in a construction contract again for a power plant, and the tribunal has passed a partial award and appointed an expert to quantify the loss. So that is also a good way to involve experts, is to really do it on time, and if not, then we have a problem at the stage of an award. The third tool is about emergency arbitrator. Now, emergency arbitrator can be appointed in less than 24 hours. And we have seen SIAC doing that in a number of cases. Within 14 days, the emergency arbitrator has to pass an interim order, either granting or refusing the interim measures. And interim measures in construction disputes are very important, because you need to preserve the site. And also there are equipments which are left on the site when the dispute arises if the contract is terminated. In ongoing contract also, we need a lot of interim measures so that the protection of both the sides are there. And normally the notice is given to the other side as per the rules, and hearing is done. It's very fast, because if you go to national courts, it takes months to get an interim relief, and by the time the tribunal is constituted. Here, the 14 days period is an outer limit, and then the emergency arbitrator ceases to have an effect once the order is passed, and the main tribunal can modify or verify the order passed by the emergency arbitrator. Third-party funding, again, is crucial in construction contract because of given the size, and third-party funders are quite interested in funding the construction disputes because they see that it's a very easy to recover their funding when the award comes, because you have the assets in terms of the project itself, and that also streamlines the arbitration and makes it very professional. SIAC, for example, has come up with a practice note on setting the standard by the arbitrators when there are third-party funders. And tribunal have the power to conduct inquiries as may be appear to the tribunal to be necessary and expedient, which shall include ordering or disclosure of the existence of any funding relationship. So transparency is something which is very important. And this practice note, although it's not binding, but this practice notes by institutions are also very helpful. And in everything, like in saving time and cost, in disclosure of the funders, and also involvement of the external funder alone shall not be taken as an indication of the financial status of the disputant party, because it's just that I have a funder, that doesn't mean that I'm not capable of funding my own dispute. It's an option given to a party. Although Singapore and Hong Kong have changed the rules, India has not done it, and I'm sure Bangladesh also has similar rules about funding the litigations by the lawyers or the third parties, where we may have to face an issue about the public policy of jeopardy and maintenance. But here in Singapore and Hong Kong, and where the execution or the enforcement of an award is going to be in another jurisdiction where it is permissible to have third-party funding, then we have seen that number of parties are opting for this option. And the tribunal can also make it known to parties if there are funding arrangements and there is nothing wrong with it. And the award can also note that. Even the confidentiality obligation will extend to the funder. So with that, I've given an overview of my thoughts on what are the challenges which are faced by the construction and real estate sector while handling institutional arbitration, and how institution can play a major role in resolving this dispute. If there are any questions, I'll be very happy to answer. Thank you.
Thank you, Mr. Tejas Karia. And now I would like to invite Mr. Anise Khan, the Vice President of Metropolitan Chamber of Commerce and Industry, Dhaka, who is the former Managing Director and CEO of Mutual Trust Bank Limited and a former Chairman of the Association of Bankers. Mr. Khan, I have to point out to you that please share your experience as a lender. I mean, as a banker, what sort of difficulties you have faced in terms of dispute between the real estate developer, who is usually a borrower, and a private individual, and what are the experience from the banking point of view? Thank you, Mr. Khan.
Assalamu alaikum, and very good afternoon to you all, especially my permanent boss, as I like to call him, Mr. Mohammad Rumi Ali, CEO of BIAC, co-panelists and viewers. It's a great honor for me to be here amongst you, speaking a few words on the subject, and I thank BIAC for inviting me. It's my habit, even if I speak for 4 minutes or 5 minutes or 20 minutes, to have some slides with me. And I will not speak to all the points that you see in the slide, but I also do it as a means of self-education or refreshing my education on the subject that I have to speak on. And many of you are here leading experts in the field, so I'm not trying to preach you, but I have assembled a presentation for my own learning, and of course sharing with many of the viewers who do not know so much. So I start here, but I will go very quickly. Please don't worry if you see the slides and the number, a lot of text in a slide. I will not speak to those, all of those. So sometimes even the most straightforward real estate transactions can result in disputes that require legal action. And the process of buying and selling real estate is also not strictly business, because homeowners are very sentimental about their properties and often feel that their personal investment in their homes lead to a high property value. I know of a certain owner of property around Dhaka city, both commercial and personal, that he will not let any builder come and build his buildings. He's built a 16-story building in Motijil commercial area, and he's built one in Baridhara J block, and he's got properties in Gulshan, Dhanmandi and Savar. Everything that he develops, he does it himself. He says, I do not like to get into disputes with the contractors or whoever. So that means that people are very sentimental about the properties. In Bangladesh, you know how it has progressed. First you had, in Dhaka especially, you had this Dhanmandi residential area and the Lalmatia Housing Society. And mostly professionals got plots there for a very small amount of money. In those days, 1 big plot cost 20,000 Pakistan rupees. Today, it costs like 200, 300 crores. So these properties were then inherited by the wives or husbands or children and now grandchildren, and when they are now converting it through companies like Mr. F.R. Khan's BTI, they are into a great gold mine. So those usually, from my experience that I've been asked, I will first attack that, banking related problems. For the most part, most of these financial transactions in my own experience have gone okay. Very few went awry. Very few disputes have happened. And there were a number of large companies that we have financed through the years. I have not faced much problem. I'll come to the exceptions in a little while. While I was at IDLC Finance Limited, we ran up a huge mortgage book, and that mortgage book hardly saw any default except for 1 or 2 individual customers who had bought apartments. They failed to because of business failures or our own assessment problems and analysis problems. But always you have the underlying asset and you have the power to sell it, not that you really want to sell it. With developers, there has been some problems, like one developer in Banani, very famous person otherwise, nice man, but he is unable to complete the project on schedule, and it's run for a very long time. So what we have done in the bank to help him from the banking point of view is that extend the tenure by 6 months and 6 months and 6 months. We don't want to kill him. We don't want to kill the investment he has already made. We don't want to kill the investment the bank has made. Then everybody loses. Bank's investment is people's money. So we don't want to lose that money. So we always look at a process of accommodation. And that gentleman, we have accommodated and done it. Another gentleman, another property, he developed a commercial property in Banani also, and he failed completely. So we have progressed against him for auction of his property, but he comes back and says, give me some more time. But he is really in dire straits and I don't think he will recover. So I think now that the bank should really go forward and auction his property and get his money back. It can't go on and on and on forever. For the other part, I have also seen very few delays by the major developers in paying back. It also means that Dhaka city is like Manhattan, Dhaka city is like Bombay, where the land is extremely expensive and very valuable, and people don't want to lose it, and developers also do not want to lose by not completing the projects. So they do complete the projects, they do want to deliver, but of course there are problems which we will talk about in a few minutes. So what are the common real estate disputes? Mr. F.R. Khan, he is the real expert here from the property side. So he has already said a few points here. I have highlighted a few. Normally, you should have a good attorney when you are beginning the transaction to advise you how to draw up the contract. Because the breach of contract is the most important part of the entire process that people attack, that you have not fulfilled your obligation. You said you would give me this, you did not give me that. You said you would give me A, B, C, D, but you gave me E, F, G. So these sort of disputes come up. Then when the buyer comes to inspect the property after he's bought it, he finds that some of them are in a great state of disrepair. The water pipes are leaking, the kitchen is leaking, there is a gas smell in the kitchen, and so on and on. So that then starts also a disagreement. And of course, frauds. Well, I have not seen much frauds in Bangladesh, to be frank, and I'm very happy that I did not see any frauds. Yeah, I see frauds in any other, in cash transactions. I've seen frauds by other bank employees, so that's a different matter altogether. So the common real estates in disputes in Bangladesh is between the landowner and developer, and between developer and buyer. The changes in rules and regulations like now. First, you could not make more than two-storied building in Gulshan or Dhanmandi and other places in Bangladesh. There are always villas. Anywhere you went, you had a villa, you had a nice garden in front or in the back. You could park your car inside the house. Don't need to park it on the street. So that was the way it was. Then they changed the rule as the population came to grow, and you really run out of land in Dhaka city, which is hemmed in by water bodies everywhere. So the rules and regulations keep changing. So 2-story to 4-story to 6-story to 12-story. Now again they're saying no more 12-story. We'll bring it down to, I think Mr. Farhan can check that, 6-story, I think. Again, that's what they're saying. So this affects the planning. A real estate project takes 3 to 4 years to deliver. So, and really affects the planning. The change in FIR rules also caused a lot of disconcert in the country. Then the valuation, the value of the registration, that is a problem. Then when the buyers buy, they sometimes do not pay the installments to BTI, for example, on time. They delay. It also then affects BTI in their own cash flows in paying their contractors. So there is no process in penalizing the buyers if they delay in their payments. But again, if I go back to banking, if the borrower, whether he is a developer or a buyer of an apartment, he defaults, the bank really proceeds and goes strict. The collections team really goes after him and threaten him, which the real estate developers cannot do. So this is one weakness they have got. Then the price escalations, COVID-19, everything closed. So the rehab said that all projects will be extended, but rehab saying projects will be extended does not have any regulatory value. It has no legal stance. The developers, the people who have given the land to the developers will say, no, you said you have to deliver. Then the force majeure, you can't do anything about force majeure. Earthquakes, floods, cyclones, and so on. You can't do anything about that. Now, why do disputes arise in the first place in Bangladesh? Because the agreements are not standardized. They're all different for different companies. You must have agreement which is like gospel for everybody, so that you don't say, oh, I developed a property with BTI, then I developed one with ABC group. Oh, ABC didn't have that. They'll come and tell FR Khan. So this should not arise. They should not say this thing. It should be standardized. This is one suggestion I'll give in this webinar. Not following the uniform building code. There are building codes. They have to be followed by everybody. And landowner is always protected from damages, and developer has to bear all costs for delays and price escalation. So now, where is the developer getting the money? From a bank. So if all this problem happens and damages happen, the developer has to pay. Developer gets less profits, so the runs into losses, but the landowner is always protected. I've already covered the fifth point here. The tripartite agreements are not registered documents, though they are legally enforceable. So there is no registration system for registering that. And already I've covered the last point, the changes in the policy. Now, you may buy a property, but you don't want to register it. You are delaying. What does it mean? You have not yet taken possession. Anything goes wrong, a murder happens, some danger happens, some problem in tort law happens. Who is responsible? The developer, because he is not yet registered, it is not in his own name. So that leaves the developer at risk. So I've already covered the second point and the third point. So ADR, so I will not go into all that. This is what I did for my own education and for the refreshing of our friends who are watching all this, the system of dispute resolution. And this little cartoon says alternate dispute resolution is facilitation, arbitration, mediation, negotiation, and the litigation is going to the ditch. So again, I'll not go into all that into detail, but when disputes arise in real estate, ADR can kick in and address the issues in a quick manner by sitting across the table. So again, mediation and arbitration, some more points over here, that they are the most affordable and least time-consuming option instead of going to the courts of law, which takes years and years and years. So keep calm and let the arbitrator handle it. He'll come and solve your issues. And when mediation and arbitration isn't possible, then what do? You have to go for litigation. You can't do anything. And if a real estate dispute alleges that criminal conduct on the part of one or more parties, that requires litigation. You can't do anything. So this is when you go to a lawyer. But I think you should go to the lawyer beforehand to have a foolproof agreement in hand so that everybody is protected. Now, why ADR? Because it takes less time than court. We all know that. It is cheaper. You don't have to spend money on court fees and on lawyers, etc., and delays and other unofficial expenses of the record. It is less formal than courts. It is confidential. It is open to the public, open to the press. Everybody sees. In Bangladesh, we have a very porous press. We have an online press. You can't say anything now. If we say anything out of turn, within 10 minutes, it will be going viral on the social media and on the digital media. So all this I will again not go. The low cost saves legal cost. Again, not just cost covered all this. Especially peace of mind. You can achieve an early closure to your dispute. I will not go into all that. So the conflict resolution, the skills are required. Absolutely, a mediator has to be empathic. He has to be assertive, because when people start fighting and quarreling, he has to come in and also facilitate and create a problem-solving situation over there. And of course, listening. So you need specialists. BIAC is doing a great job in trying to train and certify arbitrators. I know that for many years they've been trying. It's a great struggle in Bangladesh. Not many people want to attend. They want to ignore, but people really, and BIAC has done a great job, especially under the leadership of Mr. Mahbuba, Rahman and Mr. Mohammad Rumi Ali and his colleagues, in going around and talking about it with banks and other organizations. And they're really trying very hard for people to come to the negotiation table, not go to the courts of law. Again, I'll not go into this chart, but I really liked it. That's why I borrowed it to show it to you. So again, mediation is in the next exit. So go to the mediator. Usually they are voluntary. They can always walk away. They did not take sides, and is always designed to achieve. In construction projects, this is a non-adversarial method, ADR method. So you are really not, and generally construction projects are executed with high difficulty. They are complex and face uncertainty. For example, in Baridhara, when the builders went there, I spoke to a few builders, and they said, the Baridhara Society said, Saturday, and Mr. F.R. Khan will agree with me in that, the Friday, Saturday, no, you cannot come and do anything, no construction done. You cannot do anything after 5 p.m. You cannot bring in any trucks after 5 p.m. Now the developers are saying you're not allowed to bring in trucks into the city between 9 to 5 p.m. When is it we'll bring the trucks? So all these sort of problems, come up. So I'm going to end soon because I know I'm aware of the time, constraints. So here are two kings. I'm glad we settled our conflict this way. War is expensive, so we're playing chess. So there's no harm done if one king loses his king. So everybody wins, we win, you win, and there is a deal. And thank you for watching my presentation. I try to make it as quick as possible. If there are any questions, I'll be more than pleased to answer. Thank you for very good listening.
Thank you, Mr. Khan, for that wonderful and colorful PowerPoint presentation. I'm sure everyone was focused enough to see your presentation, and especially particularly the way you have explained the evolution of the nature of real estate, especially in Dhaka city, from two-storied building to multi-storied 16-floor, 20-floor high-rise building. Thank you so much. And now I would like to call Ms. Shwetha Bidhuri. She's the head of South Asia at Singapore International Arbitration Center. And she was enrolled as an advocate in 2007 and hold a Master of Law degree. And she has practiced in a law firm in New Delhi for more than a decade. So Shwetha, please share your experience as a practitioner in Delhi, and what sort of complexity and difficulties have you faced throughout your practicing career as a dispute resolution and commercial litigation lawyer? Thank you, Shwetha.
Thank you, Arthur. I think after the two Khans and Tejas have spoken, there is very little less to add, but I'm going to try my bit, to add some value to the topic in question. This is our first webinar, jointly conducted with the IAC. This is the first of the many to come. So it's absolutely an honor to be able to come and speak in Bangladesh. And while we're all discussing that how COVID has brought along so many challenges, I think it has brought us closer. It has been much easier to go to different jurisdictions to connect with different people. So thank you once again for this opportunity, and thank you for bringing BIAC and SIAC together for this joint webinar. So now, coming to the topic in question, understanding the nuances in construction industry, and particularly to identify what is the challenge we are not able to institutionalize, construction arbitration or real arbitrations. We will particularly focus on construction arbitration question, and because Mr. Khan has already detailed about it in Bangladesh. So, as Sir Queen mentioned in her speech, that today we see construction sector is dominantly now very you see a lot of cross-border activity in terms of whether it's the funding, whether it's infrastructure requirements, whether it's design, whether building requirements, etc. You're often looking at experts from different countries. Even if you have a big construction project in India, you will have players from different countries. And I'm sure that may be the case in Bangladesh as well. So, so construction sector in real estate is not only confined to domestic, players anymore. So given that scenario, given how complex these construction projects are, as Tejas already outlined, in terms of the time that it takes, the money that the stakes are very high in construction-related matters. The duration is much longer than in any other sector. And I think if you look at COVID, it is really a classic example. There may have been projects that were signed a year, 2 years ago, and nobody could have really, foreseen something like this to come forth, and which has had strong implications on the contracts, whether it's about payments being made, the liquidity crunches, etc. So the risks involved in such projects, which are of high stake nature, are also, quite high. The duration makes the risks even more palpable in that sense. So what is it that the parties need to do to be able to address and be able to resolve the disputes arising in these two sectors more efficiently and more effectively? So I think, the rule is really to go back to the basics, to understand the ground rule. One is, what is so peculiar in construction sector? B, to understand, what are the challenges, when parties are making the choice whether to go with ad hoc arbitration or to go with an institutional arbitration. So it's not just a matter of choosing ADR over litigation. It is also a matter of, within the space of arbitration, what you are choosing, whether you are choosing ad hoc arbitration or you are choosing institutional arbitration. So I think that's really the heart of the challenge in institutional arbitration. So I think I think Mr. Khan had pointed out about the mindset, and coming from India, I think Bangladesh is also sort of battling a similar issue of the mindset of understanding why is it important for us to have an institution, administer the arbitration? Why is there a need to monitor the arbitration? And I must, this is an example that I quite commonly quote. When I began my practice, there was this arbitration, that I was a part of. It was a construction-related arbitration, but it was an ad hoc arbitration. And I kid you not, from 2007, and it was in 2014 that I got to know that arbitration being completed. So it took so many years for that arbitration to be completed. I remember being part of so many hearings, actually going in in-person hearings where there were either merely adjournments or nothing substantive being done. And the cost, because those are high-stake matters, and there were big industry players involved in that arbitration, the cost was escalated tremendously. So this whole notion, the basic mindset as the starting point of thinking that ad hoc is going to be cheaper because I am not paying a fee to the institution, I think is something, is a big myth, and that's what, we need to attack, to really understand that institutional arbitration in terms of the entire cost and fee of arbitration is less than 2%. And the saving that you eventually have is much more, than the cost that you would pay because your arbitrations are not monitored. In India, we've really come a long way in terms of, the focus really being, even of the government, to institutionalize arbitration, to identify, how important it is, especially in these big contracts, especially in, sectors like construction sector and real estate, to have institutional arbitration. So in fact, there was a law commission, there was a committee that was set up to identify what is it that can be done, to really change these issues. And part of that report is very beautifully to identify the myths around ad hoc arbitration and myths around institutional arbitration. So, one I mentioned is about the cost, that the parties end up thinking that it is cheaper to go in ad hoc versus institutional. Second, it's also, they tend to think that we have more freedom because it's ad hoc. We can choose when we want to file, how we want to do it, versus an institution, setting the timelines for you, setting a framework, setting mechanisms for you. But it's actually, and if I can use this phrase, it's being how, we tend to be penny wise and pound foolish. You're thinking you're saving on small corners, but you actually forget the larger picture. So I think that's a very important point, and I think that's something that we really need to, as BIAC and SIAC together need to work on, is to identify these issues and to really clarify these misconceptions around institutional arbitration. So, going back to again, point that Tejas really mentioned about what are the peculiar features of construction sector. And why is it that you really need to identify that there is an institution mechanism in place? And I'm sure Piyush is going to get into details of how you have consolidation mechanism for joinder, which plays a very important role in ensuring efficiency of arbitration. Imagine you have multiple parties, multiple contracts, and end up having inconsistent findings. That also means multiplying the cost of arbitration if you're not able to consolidate. But absence an institutional mechanism, it would be very difficult to consolidate arbitrations. Another important point is about the drafting. When the contracts are signed, is what are you drafting in terms of your dispute resolution? To clearly identify these things. So, from that point, I just wanted to give quickly 5 points of what I think are so peculiar in construction sector, and that makes an absolute sense for parties to really adopt and absorb the ideas behind institutional arbitration. So one is that these are high stake, the stakes are very high, not just in terms of money, but also in terms of the implications. You have infrastructures being built, huge construction projects, etc. So because the stakes are so high, you can't take it lightly. You can't have it run ad hoc. You need to have a proper structure to this. Second is what Tejas also mentioned about multiple parties, multiple contracts. You have engineers, you have designers, you have contractors, subcontractors, and multiple contracts being signed individually with each one of them. So how can you sort of, in terms of your drafting of your contract, of your dispute resolution clauses, uniform, and to be able to ensure that when the need arises, for consolidation, for joinder, you are able to do that. And that can really be, sort of ensured if there is an institutional rule in place, there is an institution which is monitoring the arbitration, and then you have these mechanisms available. And, so when you're drafting, you're able to clearly identify that we would like, when the dispute arises, to be administered in terms of these institutional rules, for example, for SIAC rules or BIAC rules. Third is a very important point about the quantum, the calculation of quantum of damages. It's, I think there are only very few lawyers who are really hands-on with numbers. I am not one of those. It becomes a challenge to identify, and I'm glad we've got bankers here who are also speaking on the panel to really be, to understand numbers and nuances of numbers really well. So you need to have experts in place then it's, of course, there's a large volume of data. The documentation in construction matters is very huge. The compliances, etc. The data relating to what the progress of the project is at the time of dispute, what is the status, etc. So it's not so easy. There is a management that is required, even in terms of the documents itself. And lastly, about the technical experts, that they just mentioned. So given that it is so complex and so nuanced, it is important that parties are able to really, I think, overcome these misconceptions and really be wise about making their choices at the time of drafting of the clause. And I can't emphasize more, in terms of how important this stage of drafting is. If the clauses are drafted correctly, with this in mind, with this larger picture in mind, you're able to save so much on your time and so much on your cost. So projects which are already so high, in terms of its time, to be able to regulate that, it becomes very, very important. So I think I may have exceeded my time. And there is, of course, so much that one can get into details to understand ad hoc and institutional arbitration. But I think it's just one takeaway that I will sort of point out is to really understand and then make a choice. Don't really just go by what is being blindly spoken or said or what you have heard within the industry. To make an informed choice, to understand rules in an institutional arbitration, to understand what the impact is going to be. And I think that's really the key takeaway from me, to really make those better choices in your own contracts. So thank you so much. Thank you once again for having me as a part of this. And I'm sure whatever I have missed out, Piyush will be able to, plug it in.
Thank you, Shwetha, for that wonderful speech. And thank you for sharing your concerns. Drafting. That's a very important aspect for any type of, be it litigation or arbitration. Thank you so much. Now, I would like to call Narita Navin Khan, Barrister at Law. We are from the same law school. We are from the same university alumni, and I know her personally. And we both represent real estate developer companies in various matters. So Narita is now the head of corporate division and finance division of Rahman Chambers. She used to work for Dr. Kamal Hussain. I used to work for Amirul Islam. So we both represent big chambers in Bangladesh. So Narita, the floor is yours. Very shortly, your experience as a litigation and commercial practitioner in terms of real estate disputes.
Thank you, Asif, for this opportunity. I'd like to thank BIAC. I think this is a very timely discussion because, of course, Dhaka city, as well as all the major cities of the country, they're booming. Economy is doing very well. And you would say that Bangladesh, in spite of the COVID circumstances, the economy has been doing well. So, which is an anomaly, but it's good for the country, it's good for the economy, and it's also good for the construction and real estate sector. So you walk through Dhaka city at any given time, you'll see lots and lots of real estate construction going on. So my speech is actually more for the benefit of those who know very little about the law. So for them to educate themselves about how they can go about any disputes relating to real estate and construction. So Mr. F.R. Khan has already very kindly touched upon quite a few areas in this. So in Bangladesh, I find that there is a lot of scope for improvement in the ADR in the real estate and construction sector. So if we were to divide the law into two, only for the purposes of this discussion, I would divide it into real estate and non-real estate. The reason being that the real estate under the Real Estate Development and Management Act has mandatory arbitration provisions, whereas the non-real estate does not. So how would we define real estate? It would be any project, land property project, which has been developed. It can be either commercial or residential or mixed, but it has been developed for the purpose of sale and purchase. So this would be the relationship between the developer, the landowner, and the buyer. So
Right.
prior to
Sorry for interruption. Right. Could you emphasis on Section 36 of the Real Estate Development Act?
yes,
Especially
I'm
Section
coming to that. Yes, I'm coming to that. So before I touch upon Section 36, I would very briefly like to touch upon what issues people generally face in the real estate area. So the most common issues are that the developer fails to hand over the property to the landowner in time. The buyer fails to provide the money to the developer in time, and hence his allotment gets cancelled. And of course, even the landowner can also fail to hand over the land to the developer in time. So Section 36 actually provides an arbitration mandatory for all of these and a couple of other provisions as well. So if any of the parties come to a dispute regarding any of these, they would mandatorily have to apply to arbitration. So it's very important to note this because not a lot of people are aware that this is mandatory. So hence they go to the courts first. And that is just simply a waste of time because then the court would reject them and then they would have to come back. In fact, there was a specific case where we did this from Rahman's chamber, where the judge was not aware that this is a mandatory provision and the contract did not have an arbitration clause. So in spite of the contract not having an arbitration clause, because it was regarding real estate, of course, this mandatory provision would be applicable. So the parties would have to go to arbitration. So the judge in the lower court was not aware of that. This was eventually, of course, struck down by the higher court who said, no, you have to go to arbitration first. So it's very important to note that parties must go to arbitration first. So the process for arbitration is basically you would first have to try to resolve it amongst yourselves. If you fail to do so, then either party can send a notice to the other party and wait for about 30 days or so to form a tribunal. Now, if the parties fail to form a tribunal within these 30 days, it is only then that they can go to court to seek redress. But once they go to court, then the Arbitration Act of 2001 would apply in this arbitration. And another thing that I would like to speak upon is that so the arbitrations that I have seen in this area, the arbitrators themselves were mostly formed of ex-judges and lawyers, but there were not many people who came from the engineering or the architecture side. So this is one point that I would like to ask BIAC to address. Perhaps we could have a panel of arbitrators formed of engineers and experts, as Ms. Shwetha has also emphasized upon. We need experts for calculation of the quantum. So for all of these, this is one thing I would suggest to BIAC to perhaps form a panel of arbitrators. And of course, as Ms. Shwetha has also emphasized upon, drafting of the clause at the very initial stage. If you want to avoid litigation, come to arbitration, you must draft the clause properly. I'm not sure whether I've run over my time, but that's my very brief speech.
Thank you, Narita, for sharing your thoughts on the arbitration experience and commercial dispute in Bangladesh in terms of real sector. And now I would like to call Mr. Piyush Prasad, who is a counsel of Singapore International Arbitration Center. He's an experienced international dispute lawyer who's qualified to practice in the state of New York, US, and also in India. Mr. Prasad is also involved in administration of arbitrations under SIAC rules and UNICETRAL rules, and he's a law graduate from National Law University, Jodhpur, India. And he also have done Master of Law in University of Chicago. Mr. Prasad.
Thank you. Thank you so much. It is my pleasure to join all of you here today afternoon and speak about the SIAC experience in dealing with real estate and construction disputes. Are you able to see my slides? Okay.
Yes, yes.
Both Shwetha and Mr. Karia spoke about how at SIAC, we have dealt with a number of disputes which relate to construction and engineering. And at the cost of repeating myself, repeating what has already been emphasized, last year, like the third highest contributor to the disputes at SIAC was actually the engineering and construction sector. Having dealt with a large number of disputes from this sector, some of the issues, again, what Mr. Karia was referring, what we have seen that primarily these disputes will concern multiple parties, where, as Ms. Narita was also saying, that there will be a project developer, a land owner, and somebody say a buyer. So there are multiple parties involved. And you will also at times, or which is quite common in fact, that you will have multiple contracts as well involved. You will have engineering, procurement, and construction contract. You may have a project management consultant also involved and a contractual relation with regard to that relationship as well. You may have an operation and management contract as well. So these are some of the common features that we see are quite prevalent in this sector. Now, these may lead to some issues which are quite common, like when you have multiple parties, when you have multiple contracts, you will see that the resolution of these disputes will be delayed. It could be costly, and more importantly, there could be inconsistent decisions if they are not dealt with holistically. Now, under the SIAC rules, there are some provisions that I'm going to speak about in my presentation, which could help in dealing with these pitfalls and could lead to an effective dispute resolution. Mr. Karia mentioned about this, and I'm going to take a bit of a deep dive into this. Rule 6, which deals with multiple contracts. Like, for example, if you have an offshore engineering, procurement, and construction agreement, you may have an onshore EPC contract as well. And if there are multiple parties, they could all be also parties to, say, a coordination agreement. Now, if you have disputes, usually don't arise out of just one relationship, but you may have to invoke several of those. Now, if you do that separately and discreetly, of course, that will be a more costly, proposition. But under the SIAC rules, you have the option under Rule 6.1 A or B that you can commence multiple arbitrations at one go, and along with the invocation of those arbitrations, you can file an application for consolidation. I'll come to that a little later. But what it does, and these are really bespoke rules which are meant for situations which are quite common in real estate and construction disputes, is that they provide certainty in the commencement of multi-contract disputes. So there could be no issues as to when these arbitrations commence. So you have something which can be very useful when you have multi-contract disputes. We also have two more rules, which Mr. Karia had alluded to in his presentation. And there's something, first I would like to speak about Rule 7, which talks about joinder. It is very common that you may have, Mr. Khan mentioned about a Japanese contractor, who was involved in a construction contract in Bangladesh. So it is not uncommon that the Japanese contractor may have a local Bangladesh subsidiary. And for whatever reasons, COVID has led to a cash crunch in the economy, but I'm glad to know from Ms. Khan that Bangladesh economy is doing well. But it is possible that there may be an insolvent party that you are in dispute with, and you may want to bring in the solvent parent company. So there is a provision under the SIAC rules under Rule 7 that you may add a party or join a party to your arbitration if that party A either agrees to join or if that party is prima facie bound. And to explain this a little further, you may have, say, a joint venture agreement between a Japanese company and a Bangladeshi company, and a further agreement, like a development agreement between the Bangladeshi subsidiary of the Japanese company and the Bangladesh counterparty. So you may be able to bring in the solvent parent company in the arbitration fold by way of this rule. Now, I would also like to touch upon consolidation, which again is very critical for these kind of disputes where you have multiple contracts. Now, what's interesting about consolidation is that you can bring all your arbitrations and avoid multiplicity in terms of proceedings when you have provision of consolidation. Now, when does this become applicable? Of course, this provision was introduced in the SIAC rules in 2016. Party agreement, of course, remains the cornerstone of arbitration. If there is an agreement, then there are no issues. But something which is very commonly seen in such disputes is that there could be several claims which arise during the lifetime of a contract. For example, if road construction. So as the road is being developed, you may have a dispute at the beginning, a second set of disputes during somewhere in the middle of the project, and something towards the end. So under this consolidation provision, if the claims are made under the same arbitration agreement, all those claims can be consolidated into one single proceeding. So this obviously obviates the risk of inconsistent decisions. That if you have a live claim, which is before the tribunal, and during the time that that dispute is being arbitrated, if you have new claims, under Rule 8 of the SIAC rules, you can file for an consolidation, and the new dispute will also go before the same tribunal, and the tribunal can deal with both the disputes in a holistic manner. One of the criteria also for consolidation of the SIAC rules is that the arbitration agreements are compatible. And if there is a relationship between, say, a principal agreement and ancillary agreements, those disputes can also be consolidated under the SIAC rules. What's interesting and what sets the SIAC rules apart is that unlike ICC, which requires an identity of the parties, there is no requirement for identity of parties under the SIAC rules, which means that arbitration A can be between party 1 and party 2, and arbitration B can be between party 2 and party 3. But all those three parties can be in one single consolidated arbitration under the SIAC rules. A very important consideration and a very important advantage of this, which is very relevant for the kind of disputes that we are speaking about at this webinar, is actually cost saving. Now, if there were 5 arbitrations, each with a sum in dispute of 20 million, the average cost and therefore the cost of those 5 individual arbitrations would be quite high. Except under the SIAC rules, the parties will have the option to consolidate those 5 arbitrations into a single arbitrations. And as you can see on the slide before you, it is going to lead to a substantial saving in cost saving that the parties will achieve because of this. And of course, you will obviate the risk of inconsistent findings. That's something that is, again, very important and relevant for these disputes. Lastly, and Mr. Karia again mentioned about this, and I'm going to get into slightly details that give you an overview of how this actually functions. Ms. Yoko was mentioning that this year has particularly been busy for SIAC when it comes to emergency arbitrations, and understandably so. I mean, COVID has sort of disturbed general equilibrium that everybody was used to, and in a lot of situations, parties are for circumstances which are outside their control, unable to honor their commitments under contracts, and this is where it becomes very relevant. Very recently, I dealt with a dispute here, which was related to a power construction of a power plant, and there again, which is something very common, you will have a performance guarantee, being given in large-scale construction disputes. Due to some dispute between the contractor and the owner of the power plant, the owner wanted to invoke those bank guarantees. And this almost happens on a Friday evening, where on a Monday, that those bank guarantees will be invoked. Especially in such tight timelines, courts may not be the most efficient, venue for resolving such a dispute. And that's where this is probably the best setting I could, show where emergency arbitration proceedings can be very useful. So under the SIAC rules, you can file for the appointment of an emergency arbitrator, and this happens within 24 hours. And it is not one business day, and it is literally 24 hours. So we would get an application on a Friday evening at, say, late in the evening at, say, 7 p.m. And we would get cracking on working on that application. If it is accepted by the SIAC president, the appointment will be made within 24 hours. And that's your one-day timeline within the SIAC rules. Now, the tribunal, the emergency arbitrator has the same powers as a tribunal, and he also has the power to order any interim relief. Now, what becomes interesting in the example I gave, that within 48 hours of the appointment of the emergency arbitrator, he can pass any interim directions as well. So it could well be that on a Sunday, he tells the party that do not invoke the bank guarantee on the Monday and wait till these proceedings get over, which will get over in a span of 14 days. And in my last experience that I dealt with, it actually got over on the 13th day itself. So in this situation, it becomes very relevant. You choose alternative dispute resolution mechanism and rules which provide for the avenue for invoking emergency arbitration. In fact, SIAC happens to be the first Asian arbitration which introduced EA provisions in our rules back in 2010. So over the last decade, we have gathered experience in dealing with such applications. Next, I'll just give an example of some of the relief sought and successfully obtained in SIAC emergency arbitration proceedings. And the first one is actually very relevant for our discussion today. The emergency arbitrator allowed the company access to inspect a property development where the respondent was effecting alterations to properties to remedy defects. So this happened in a scenario what we are discussing today, where the company wanted access for inspection, and there were alterations being made to remedy defects. So we have seen disputes from this sector where emergency arbitrator applications have been filed. And of course, there are other examples as well that's on the screen in front of you, where a freezing order has been passed against respondents, which enjoined them from transferring assets, and also to order disclosure of financial records. Not just disputes that we have seen in the construction sector. In fact, we've seen a number of emergency arbitrator applications, and I was giving an example before this, and you will see that even in this sector, it is quite common for SIAC to be dealing with emergency arbitrator applications. And again, Ms. Yokoi mentioned about the global nature of disputes that we handle at SIAC. Even in cases relating to emergency arbitrator, we have seen parties from across the globe, not just from common law jurisdictions, but also civil law jurisdictions. So that's about it from my presentation. One last thing that I wanted to mention, and it goes to the point that Ms. Narita Khan was mentioning before me about a panel. I just wanted to highlight that SIAC has a panel which is of arbitrators, which is available for everybody to see on our website. It has more than 400 experienced arbitrators and over 100 arbitrators who have experience in dealing with real estate and construction disputes. So if you need to refer to that list, you're welcome to check out our website, which has the list under SIAC panel. That's it from my side. If you have any questions, please let me know. Thank you.
Thank you, Mr. Prasad, for sharing your thoughts. And now I would like to call Ms. Mahbuba Rahman, who is the General Manager of Bangladesh International Arbitration Center. She graduated from Jahangirnagar University doing honors and master's degree in statistics. And she's also accredited mediator of Thailand Arbitration Center and consultant of Kunming International Commercial Arbitration Service Center in China. Ms. Mahbuba.
Thank you, Mr. Asif. Today, I will share the scenario of real estate and construction sector in Bangladesh and a few of my experience. In Bangladesh, the construction sector is one of the key driving forces behind the economic boom of our GDP. In urban areas, it has become very lucrative for the landowners to jointly develop land with the developer company, which generates a lot of upfront cash for the landowners without any investment. Due to the attractiveness of the deal, landowners sometimes avoid to perform the due diligence of the developer. The real estate is a heavily litigated sector in Bangladesh. Due to land fierce competitions, developers tend to offer landowners more than they can afford to give. Real estate construction have categories like residential, commercial, industrial, and public projects. Residential real estate is less costly and involves less individuals. Commercial, industrial, or public projects are more costly, involve multiple parties, which may sometimes involve foreign investors. Residential real estate disputes arise between the landowners and developer or developer and buyers. With the assessment of delay, extension of time, and contract variations. There are numerous agreements with the landowners who are willing to hand over the land to the real estate developer companies for construction. Contracts are established between the landowner and real estate developer companies under Contract Act 1872 and relevant laws prevalent in Bangladesh. Lack of knowledge of law and absence of safeguard clause drive parties to face problems and lead to disputes arise between them. Legal due diligence actually help the parties involved in assessing their risk, cost, and time. For safeguarding the interest of the parties, the government of Bangladesh enacted the Real Estate Development and Management Act 2010. The government issued instruction making it mandatory for the developer companies to obtain registration from Real Estate and Housing Association of Bangladesh, REHAB. The Real Estate Development and Management Act 2010 provides that in case of dispute between landowner and developer, the parties will try to resolve mutually at first instance. However, if such an attempt fails, both the parties must try to resolve the dispute through arbitration. If arbitration fails or one party does not respond to the invitation of the arbitration, only then a case can be filed in the court. In case of amicable settlement, REHAB has their own platform of mediation for their members only. If an aggrieved member seeks assistance to resolve any dispute with another party, rehab tries to resolve the issue amicably between the parties through a sort of mediation by their mediation and customer service department. But there is no legal process nor any set rules for such mediation. Moreover, they don't have any trained or neutral mediators. Eventually, parties try arbitration under Arbitration Act 2001. Over the years, various methods of ADR have been introduced in the construction industry as a means to avoid lengthy and expensive litigation. But unfortunately, parties seldom opt for any institutional arbitration. In many jurisdictions, disputants prefer arbitration over other ADR mechanisms because of the enforceability of arbitral awards and avoidance of specific legal systems and national courts. Latest trend in construction dispute indicates that arbitration's popularity is diminishing. The report of Arcadis Global Construction Dispute 2019 shows that mediation is now the second most used ADR after party-to-party negotiation, while adjudication occupies the third most used ADR methods. A flexible and voluntary mediation process offers a speedy and cost-efficient resolution to dispute that surpasses what arbitration and adjudication offer. In May 2018, I joined the Asia ADR Week and Construction Industry Payment and Adjudication Act (SIPA) conference organized by Asian International Arbitration Center AIAC in Kuala Lumpur, Malaysia, where I observed that AIAC has separate ADR rules for construction disputes. Malaysia faced the same problems before 2014 as Bangladesh is still facing in construction disputes. The unswerving growth of the construction industry in Malaysia has given rise to several construction-related disputes, which is being effectively addressed by the SIPA Act, aimed to resolve payment disputes. Within that time period, 2014 to 17, AIAC has administered over 1,400 adjudication cases with 2017 recording the highest number of adjudication cases with a total number of 708 cases alone. AIAC also conduct adjudication and mediation training program for developing skilled adjudicators and mediators to resolve the construction disputes. BIAC's mandate includes training as well, like AIAC, with the support of builders and end users. BIAC may work as an institutional platform to help resolve dispute in real estate and construction sectors. Our training programs will continue to address these sectors. China is implementing USD 10.4 billion worth of infrastructure project in Bangladesh, which is the second highest in South Asia. There are already ongoing disputes between the investors of China and Bangladeshi contractors. For this, the Kunming International Commercial Arbitration Service Center, KICASC, Kunming, China, and BIAC signed an agreement on joint promotion of the establishment of Sino-Bangladesh International Construction and Engineering Dispute Adjudication Expert Board to establish a professional mediation mechanism in the field of construction and engineering in both countries. We hope that as this mediation mechanism is developed by Bangladesh and China jointly, parties from both countries will prefer to use these methods of institutional ADR to resolve their disputes in the construction sector. Emerging disputes in this sector is not being properly addressed for lack of knowledge, provision of pre-trial mediation and arbitration, and also institutional support to resolve the ever-growing issues. BIAC are trying hard to reach out to the stakeholders in this development sector and always insist to insert an ADR clause in all contracts so that dispute can be resolved amicably and efficiently before parties are bound to opt for judicial proceedings in a country like ours, where courts are already overburdened with backlog of approximately 3.7 million cases. Thank you all.
Thank you so much, Ms. Mahbuba Rahman. And if anyone has any question, they can post their questions on the chat box in this webinar. And now, due to time constraint, we won't be able to answer all of your questions. But if you have any, you can post it. We can wait for a minute or two for the questions to come in. And then we can proceed to the closing remarks of our Honorable CEO. Thank you. Okay, now I would like to call the Chief Executive of the Bangladesh International Arbitration Center, Mr. Rumi Ali. He was working for ANZ Greenlist Bank in Bangladesh since 1975 after completing his master's in economics from Dhaka University. And he's a former deputy governor of Bangladesh Bank. And Mr. Ali was the chairman of BRAC Bank and CEO of Standard Chartered Bank in Bangladesh. And he also acted as a chairman of AV Bank Limited. Mr. Ali, please grace us with your closing remarks. Thank you.
Thank you. Ms. Lim Sok Hui, CEO of Singapore Arbitration Center, the speakers, and I must single out Anis because when in his opening address, he did say a few things about me. And I have to say, Anis, thank you very much for being here with us. I know you are an industry expert on banking, and I saw the moderator ask you specifically for comments from the banking sector. And since I am mainly from the banking sector, I was waiting for your remarks. I thought they were well put. Thank you very much for being with us. And I also must welcome our expert from the construction and real estate sector, Mr. F.R. Khan, who is again a very respected member of that fraternity. And let me say, the arbitrator community also respect you. And I'm sure in future we'll see you here using arbitration facilities at BIAC more frequently. And the rest of the speakers, thank you very much for being here with us. I feel privileged to be speaking at the first ever webinar, which has been put together by SIAC and BIAC. I'll say SIAC for not to say every time the long thing. We also shortened ours to BIAC. So SIAC and BIAC, thank you very much, particularly the speakers from SIAC who are representing SIAC and the distinguished audience. Welcome all. I think we chose this topic quite intentionally. I think the construction sector in every country almost actually drives the GDP in a big way. And Bangladesh is not an exception, and therefore, it is very important for that sector to be efficient. And although, we are lucky that there are not so very many disputes, but every time a dispute happens to any project, it is a cost. And costs multiply if you cannot resolve disputes very quickly. And that is why I think it is important that the sector, which, as you heard many of the speakers who are much more knowledgeable than I am, who have clearly stated that this sector actually has not really formulated the framework, or the regulatory framework is there, but dispute resolution framework around it is not very well defined. The result is disputes often take a long time to address. I think, this is where ADR can play a very important role in reducing costs in the sector. I'm not talking about an individual. You can imagine what happens when an individual project goes into a dispute. And as Anis mentioned in his speech, that people are very sentimental about the land. And most of the real estate sector actually relies on land which are inherited or bought by the person himself. And therefore, I think this is a global phenomenon that human beings have some sort of relationship with land. And therefore, they become very emotional whenever a dispute arises with land. And they can become unreasonable too. So if you do not have a set framework to deal with them, you get into the area of emotional response, which cannot be good for dispute resolution. That is why ADR is so much helpful, because in ADR, you can take into account the emotional side as well in the mediation. And in fact, in mediation, psychology plays a very important role. So I think, I've seen mediation actually, and as Mahbuba mentioned in her report, nowadays, most of them are actually done by themselves, the parties themselves, and then they go for adjudication, and then they go for mediation. So it is clear that people, they prefer to actually speak among themselves to resolve these disputes. And that's what I'm talking about. Again, I'm not an expert. We heard from the experts, and they know much, much more than I do. I can only say that BIAC is here to help you address your insecurities, your issues, both the developers and the people who are actually have a land to offer. We can help you. Please do take advantage of our presence and the facilities we offer. And I think this is all I had to say. I did take note of Mr. F.R. Khan's comment about our costs. But as another speaker said, it's never more than 2%. I can assure you, it's certainly not close to what you pay your lawyers. They are in multiples. So I think, however, since you have made that comment, I assure you again that we'll have a very close look at it. And if there are areas where we can improve, you will see that improvement. And I also, I think one of the speakers mentioned about a panel. The panel does not have any, expert arbitrators. I think that's a very, very good suggestion. Thank you very much for that suggestion. We are taking it on, and we certainly need expert arbitrators for the engineering, who have engineering knowledge and who have knowledge of the industry or that particular area. For example, IT would need some level of expertise too, and we will in future include these people in arbitrators. So with those words, I'm thanking you all again. You're all, I'm sure it's 1 o'clock, more than 1 o'clock, in fact, towards it's 1:30 almost. And you all, I will not keep you from your lunch. Once again, thank you very much. I thank the speakers. I thank SIAC. I thank the speakers, particularly those from who are representing SIAC over. Thank you very much for coming. I don't want to go through all the names again. So, and in the end, I must also thank our audience who has been patient with us and listened to all this. And in the end, finally, I'll thank my team at BIAC who helped to put this up. Thank you all very much and hope to see you again. I think